6:30. I think we should start because our two speakers have quite a bit to go through. So welcome everybody to our first GAPLA online talk of the new year, and Happy New Year. And for the ones who don't know GAPLA, it's a non-for-profit organization for lawyers in German-speaking countries and Australasian jurisdictions. My name is Juliane Werther, and I will be your host today. I got my board colleague, Michael Kobras, with me today. Hi, Michael. And our speakers are Angelika Yates and Till Freyling. Angelika is a partner with Addisons in Sydney, and she's trained in German and Australian law, but is practicing currently in Australia. She has, I think, almost 20 years of experience in corporate and M&A legal matters, and will give us the Australian perspective this afternoon.
Yes, thank you, Juliana. And hello, everybody.
And Dennis, would you like to introduce Till?
Yes, of course. It's my pleasure to introduce my colleague and my friend Till Freyling. Till is a lawyer here at our Cologne law firm office from LLR, and he advises on complex projects in the area of corporate law and financing. He's also an expert in the field of mergers and acquisition. Till studied law at the universities of Münster and Munich and completed his legal clerkship at the Higher Legal Court in Düsseldorf, including a station in an international law firm in Moscow, which I didn't know until yesterday. He was admitted to the bar in 2008 and joined our Cologne office in 2010. Yeah, and now I'm very excited about your presentation.
Thank you, Dennis.
And just a little question to our speakers beforehand. Would you prefer that questions are asked afterwards, or could people also put them in between?
For me, actually, I think just a small group. I'm happy to take questions anytime, even throughout the presentation. And but at the end of the, you agree to?
Yeah. Absolutely, absolutely.
Yeah. But also,
Okay.
of course, if people would like to ask at the end, we have a bit of time at the end as well for questions. Yeah.
Okay, very good. So yeah, then you can raise the hand, put your questions in the chat. I will monitor that and put that up. Okay, so please, the floor is yours.
All right. Well, first of all, I'd really like to thank Angelika for creating those PowerPoint slides. As I said before, it's not my most favorite tool, and I'm very, very impressed at what you did with the presentation. It's really nice looking.
Thank you. Okay.
We have biggish agenda. Did you want to give an overview, Angelika, since you put it together?
Yes. Okay. So yeah, the agenda for today is we will actually swap between German law and Australian law. So we have a few slides about the corporations under German law, then under Australian law. Then we talk about the directors and other officers in the GmbH, the AG, and the Pty Limited and Limited. And then we talk about general requirements for directors. And then we go into a bit more detail about who the also duties and so on, and what are the key duties. Then we will also talk about the business judgment rule, which is an interesting one because it applies under German law and under Australian law. And I think it's very similar in both jurisdictions. And then a little bit about insolvent trading, and then personal liabilities of directors. And then at the end, we give some practical tips how to minimize the risks. Okay. So, and I think we start now with the corporations under German law. I hand over to Till. Yeah.
Yeah, thank you, Angelika. In Germany, we have quite a large number of legal forms. In this presentation, we're going to look at the two major ones of them, the GmbH and the AG. To summarize things, the GmbH is a closed corporation. It's meant for a smallish number of shareholders that are involved in the day-to-day management of the company. Shareholders can basically structure the GmbH legally as they see it fit. For those reasons, and for the reason that the GmbH is geared towards a constant identity of shareholders that are not changing day to day. It's very useful as a subsidiary in a group structure. The AG/SE, which is the European level equivalent, on the other hand, is an open corporation. It's geared towards a large number of shareholders who may change from day to day. That's why the transfer of shares in the AG is much easier than the GmbH. Shareholders are not involved in day-to-day business of the company. They are thought as investors. For this reason, the AG is a highly standardized legal form. It can be listed on the capital markets. In this case, numerous obligations will apply to the management, which we will not be going into today. And for that reason, all in all, it's more applicable as a parent group entity instead of a subsidiary.
Yeah, okay. And under Australian law, we have basically also two corporate structures. One is a proprietary company, which is the abbreviation Pty Ltd. And this is comparable to the German GmbH. It's typically operates small to medium-sized businesses. So it's used across the board of different sizes like startups, but also subsidiaries of large multinational corporations. These are mostly in the form of a Pty Ltd. And there is a maximum number of shareholders, which is 50 non-employee shareholders. And a Pty Ltd is not suitable for listing, because also it is prohibited for a Pty Ltd to raise funds from the public. And with certain exceptions, but generally can't do that. And as I said before, it's a very common legal form for subsidiaries of multinational groups. So if we look at the subsidiaries of the big German companies here in Australia, they're all Pty Ltds. And also there's a bit of flexibility here, because it's no longer necessary to submit the constitution with the Australian Securities and Investment Commission, which is the equivalent of a Handelsregister here in Australia, but it's centralized. Therefore, it's a bit different to the Handelsregister system in Germany. But so the constitution of the Pty Ltd doesn't have to be submitted, so it's not publicly available anymore, which makes it a bit hard for outsiders to get an idea what the constitution might look like. But it makes it easier for the company, because they can change the constitution and don't have to make it public. And similarly, there's the Pty Ltd is not required to submit financial statements with ESIC. If it is a small Pty Limited, which depends on the number of employees, so it must be less than 100 employees. I think it's now 50 million assets or 12 million revenue. Or other way around, I have to look it up again, but so it's actually quite a large threshold before you become a large Pty Ltd. But I also would like to mention here, because it's quite relevant in the context of subsidiaries of multinational companies, groups, there is an exemption, so that there is actually a requirement that foreign controlled small proprietary companies that are not part of a large group must submit their financial statements with ESIC, unless they can rely on an exemption which has certain conditions. And the not part of a large group is defined in a way that actually it does not count the overseas businesses. It only focuses on what is done in Australia. And therefore, most of the subsidiaries of German companies here in Australia, they can rely on this exemption and don't have to submit their financial statements. But you have to be aware of this, and because you have to pass a resolution and lodge a form with ESIC, otherwise you cannot rely on this exemption. Maybe that's a bit more, that's a bit detailed, maybe, yeah, but just I want you to be aware of that. Next slide, please. Okay, and then we have the public company, which is called a limited, and similar to the German AG. There is no maximum number of shareholders, so it's suitable for public listing, and it also can have passive shareholders, or most often will have passive shareholders as investors. And the corporate governance rules are stricter with respect to a limited than they are for a Pty Limited. And for an example, also the constitution here needs to be submitted with ESIC, and also audited financial statements need to be lodged with ESIC on an annual basis.
Okay, right. Having now an overview over the kind of legal entities that exist in Germany and Australia, let's have a look at what the directors and officers do in those companies. The GmbH has a one-tier management board. As I said in the introductory words, the shareholders can design the GmbH to their needs, so they are also free to install a secondary board. It becomes mandatory in certain large companies, depending on the number of employees. In general, in a GmbH, the shareholders are free to set the rights and obligations of directors. And what's very important, in particular in group situations, they can issue instructions to directors. The AG, on the other hand, has a mandatory two-tier board structure, existing comprised of a management board and a supervisory board, plus there's the shareholders meeting. The shareholders appoint the members of the supervisory board appoints and dismisses only for cause the management board. The supervisory board, however, cannot issue instructions to the management board. This may anecdotally lead to interesting situations in M&A deals when you are selling a AG, because in that case, the management is not dependent on instructions and can decide on their own whether to issue confidential information to the potential sellers or not. This may be rather difficult for sellers. Right, over to Australia again.
Yes, okay. So the Pty Limited must have at least one director, and a company secretary is no longer required, but can still be appointed optionally. And at least one director must reside in Australia. So one resident director is required. And there's no prescribed maximum number of directors. However, usually Pty Ltd will have not more than 5 directors. It's more likely to be like 2 or 3, but not any more than that. And then the difference here also is that the directors to the German system, the directors are appointed by the other directors and not by the shareholders. And but the shareholders have the power to remove directors and can also then reappoint a director. But normally the ordinary appointment is done by directors. And as a very different from the German GmbH, the directors are not obliged to follow directions given by the shareholders. And it's rather quite the opposite. If the directors would blindly follow shareholders' directions, that would most likely result in a breach of their duty to act in the best interest of the company, or could result in that duty. So a breach of that duty, because the directors have to act always in the best interest of the company and not of a particular shareholder. And if they follow directions where there is a conflict of interest between the interest of the company and the shareholder, then there would be a breach. And there's only one exemption from this, and it needs to be in your constitution. So for a 100% owned subsidiary, the directors can take into consideration the interest of that one shareholder, because there is only one. I think it's okay. But you need to have a provision in your constitution that allows the directors to take this interest into account, or act in the interest of the shareholder. But that still doesn't make them bound by directions. It only means that they cannot be accused of having a conflict of interest by acting also in the interest of the shareholder company. So it's very important to make sure in a 100% owned subsidiary that you have this provision in your constitution. And in the limited company, you must have at least 3 directors, and you must have a company secretary. It can be the same person, so one person can be director and company secretary. It doesn't have to be a separate person. And at least 2 directors must reside in Australia. again, here also there's no prescribed maximum number of directors. Normally the board of a limited would be a bit bigger than the board of a PTY limited, and especially larger companies, larger limited companies also have non-executive directors. They have a mixture of executive directors, meaning directors that are also involved in the management of the company, like the CEO and CFO, but also non-executive directors or independent directors that are on the board to have a bit of a balance. And it's not quite like a two-tier, but it is at least two different types of directors on the board, with the non-executive directors and independent directors giving a balance to the executive directors. And again, here directors can appoint directors, but different to the PTY LTD, every director that is appointed by the other directors must be approved at the next general meeting by the shareholders. And there is also very often we have in your constitution rotation provisions, meaning that the directors have to resign after 2 years and then have to be can be up for re-election at the AGM, but they have to after a certain number of years they have to resign and be re-elected. That's next slide.
So who can be a director? We talked about it in advance. In Germany, at least, only natural persons can be directors. So different from other jurisdictions where a company can be a director, that's not possible here. In general, most people can be directors. They are independent from legal form. They cannot have been convicted for certain economy-related crimes within a 5-year period before their appointment. That's basically bankruptcy-related crimes. There's no nationality or residency requirement. Each company must have at least one director. There's no maximum number of directors, but usually, depending on the size of the company, it's between 1 and 4 directors. How are directors appointed? In general, the appointment is effective from the resolution of the competent body on, whether it's the shareholders meeting in the GmbH or the supervisory board in the AG. The obligations that a director is subject to apply immediately from the time of appointment on. The appointment and the removal must be entered in the commercial register. Third parties may rely on the commercial register being correct, but with respect to the duties and obligations of the director, the registration with the commercial register does not have effect. They apply from the time of appointment on.
Mm-hmm. Yeah, it's very similar actually in Australia. So only natural persons can be directors. And but we have a residency requirement, as I mentioned before, which leads to the necessity that subsidiaries of multinational groups, they not always have somebody here on the ground, and then there are service providers available, so you can actually normally find somebody who offers that service, but that of course is an additional cost to running the company here, because they charge a fee for that, of course. And the fees are not very low because there is quite a high risk associated with the position of a director, and therefore I think it's around $10,000 to $15,000 a year that you have to pay for a resident director. And again here as well, there is a certain convictions, or if the director has been a director of a company that has gone through insolvency or into insolvency, then they are barred for 5 years to become a director again. And that is one of the reasons why recently a director identification number was introduced in Australia, which is a little bit of red tape now that you have to follow, because so now every director of an Australian company has to have a unique identification number, and they are linked to that number, and that should make it easier. That was the thinking behind it, to trace directors that have been convicted or have been at a board of an insolvent company, to make sure that they're not being appointed as a director under a slightly different name. So that's why this requirement has been introduced, and something to everybody needs to be aware of, that is on the board of an Australian company right now, or wants to become a director of an Australian company. Especially for overseas directors, this requires lodgement of notarized documents, and yeah, it's a time-consuming sort of task to get that number if you're not an Australian resident. Okay. Yeah, as mentioned before, directors are appointed by directors, and before they can be appointed, they must provide a written consent. That's one of the requirements here. And same as in Germany, the duties and the powers apply from the time of appointment, which is when the resolution appointing them is passed. Then there is a register of directors, which is kept by the company itself. So every Australian company has a company register, and in that company register, there's certain sub-registers, like directors and members registers. And they are the decisive documents, not the registration with ESIC. The ESIC registration is just of a declaratory nature. But if you really want to know who is on the board or who is a shareholder, you have to look at that record that is kept by the company itself. And again, same, but when it comes to who is able to exit or to rely on whether documents have been executed properly, third parties can rely on the ESIC records as well.
Okay, so one question that keeps popping up in corporate law lectures is who exactly owes directors' duties. And there are several constellations that we see both in Germany and in common law countries quite often. Beyond the normal directors' duties are also owed by de facto directors. We call that faktischer Geschäftsführer, which is a person who has been appointed as a director but whose appointment resolution was invalid. Those are practically constellations where the appointment resolution has been contested by other shareholders afterwards. During the factual tenure, the duties apply to that director, independent from whether, from a purely legal point of view, the application has been invalid from the beginning. Then there's the shadow director. If the nominal director is just a straw man and there is somebody else acting behind the director, there's a lot of discussions about that theoretically. The obligations to the director apply to the person behind that straw man. I've never seen that in real life, so it's more of a theoretical discussion. And then there is an apparent director who has been removed, but who's still registered with the commercial register. In general, the duties do not apply to that person. However, third parties may rely on him still being appointed. So that person may be served documents for the company, for example.
Yeah, and again, it's very similar in Australia. So of course, first of all, the person properly appointed as a director has these also duties, but also a de facto director, very similar to the German scenario. It's a person acting in the position, but the appointment was somehow defective. They also have to comply with the duties. And then we have the shadow director here as well. And interestingly, a shadow director can also be a company. And there was actually a case here in Australia, Basel versus Apple, where the company actually went insolvent, and the shareholder behind the company, normally in the insolvency you have a the shareholder of course is not liable for the debts of the company, but because they were trying to regard the shareholder as a shadow director, then the shareholder would have been personally liable just as a director for insolvent trading. And that was the angle in that case, and it was quite interesting. So that they were trying via that shadow director concept to get behind the company to the shareholder for insolvent trading liabilities.
Okay, that's a very interesting thought.
Yeah.
To whom are the duties of the director owed? Under German law, directors exclusively owe their duties to the company. The question is, what are the interests of a company? Because a company is a legal fiction per se. Generally, the concept is, and that's very strong, especially in open companies, that the directors must focus on the long-term success of the company. Their remuneration must, in case of listed companies, be geared towards the long-term success of the company. From a practical point, the focus shifts from the interests of the shareholders to the interests of the creditors the closer the company comes to insolvency. So in an active company, the directors primarily have to consider the interests of the shareholders behind the company, but the closer the company edges to insolvency, the more the creditors of the company come into focus. In general, directors do not have obligations vis-à-vis third parties unless that's explicitly stated in applicable special law, which is very, very rare. The same applies to creditors. Creditors generally only have claims against the company, but not against the director. If the director is guilty of some sort of misfeasance, in that case, creditors may make claims against the company, which then may make claims against the director. In fact, considering the interests of third parties may be a breach of an obligation of a director. For example, in case of substantial and unwarranted donations to charity, that may be a breach of the obligation of the director only to consider the interests of the company.
Yeah, and in Australia, also again, similar, the directors owe their duties to the company as a whole and not to the individual shareholders. I talked about that before, but also to the creditors, in particular when the company is in financial distress or close to insolvency, similar to Germany. So often the directors have to consider when they make a decision, it should not be prejudicial to creditors. That is a requirement in a few cases, so they have to take that into consideration. And also under other legislation, like special legislation that is trying to protect employees, for an example, or the environment, there are other stakeholders also the directors may need to take their interests into consideration as well. Otherwise, they would breach those laws. Yeah.
Where do duties come from? Just a short overview since we're getting close to the end. Basically, from general corporate and civil law, in particular the duties of skill and care. Directors also have to follow the company's articles and the rules of procedures if applicable, as well as instructions issued, if any.
Yeah, and in Australia, of course, primarily, so the duties come from the common law and equity. That's where they all originated from. And then in the Corporations Act, we now have some of these common law duties now in the special provisions of the Corporations Act. And then I mentioned before, there's other legislation where directors have certain obligations. And then again, also here, the company's constitution or board charter, or also group and company policies.
So what are the key duties of directors under German law? Basically, it's a very general duty of skill and care, applying the business judgment rule, which is kind of identical in Germany and Australia, according to my understanding from the slides. They are limited by third-party interests, in particular by creditors, which limits the right to pay dividends to shareholders. Dividends may only be paid from net earnings or from available capital in the GmbH. Near insolvency, in particular, shareholders have directors have somewhat stricter obligations. That in particular includes not making unnecessary payments, informing shareholders, and filing for insolvency unless it can be reasonably averted.
Yes, and yeah, in Australia, there are 4 key duties. That is a duty of care, skill, and diligence, which is very similar to the German one. Then there is a duty of good faith and proper purpose, duty not to misuse position or information, and the duty to avoid and disclose conflicts of interest. But it's just really common sense. So as long as the director acts honestly, in good faith, and to the best interest, in the best interest of the company, you virtually comply with these key duties. Yeah, and the business judgment rule is there is a provision in the Corporations Act which spells it out, and it's in relation to the duty of due care and skill and diligence. So it's like a defense which addresses the issue that directors have to often make difficult business decisions, and sometimes, of course, they might make the wrong decision and the company may suffer a damage because they made the wrong decision. But if they applied these preconditions here, then they should not be liable because they made the decision based on information that they have obtained or in good faith, and they really believe that the decision would have been in the best interest of the company. And if this is all the case, then they should not be held liable. And I think the same concept applies in Germany. It's literally and absolutely the same, which is why we do not have a separate slide for Germany, since it's absolutely identical. Yes, and again, here's some practical tips. So if you want to rely on this business judgment rule, you just have to obtain all relevant information. You have to, if there is more complex issues, also seek some expert advice. And you have to consider all this information that you have collected, discuss the matter at board meetings, and then document all these steps. Then you should be fine. That is literally the same in German law, as you can see from the German flag that is also over this slide. Okay, then here's a bit of a long slide, and I will make it very short. That's the duty to prevent insolvent trading, which is a very important one in the Australian Corporations Act. And yeah, it's a bit of a different test for insolvency in Australia than it is in Germany. So in Australia, the insolvency test is really just the question whether or not the company is able to pay its debts if and when they fall due. So it's more like a cash flow test than a balance sheet test, I think. And here again, a director might be personally liable if they incur a debt that whilst the company is insolvent, or if that debt would result in the company becoming insolvent, then the director is in breach of this duty and may be personally liable for that debt that they have incurred. So it's quite an exposure, and it's a bit of a dangerous area. That's why sometimes directors would maybe ask for a parent company guarantee. Like if the director of an Australian subsidiary, then they could ask the parent company in Germany to give them a parent company guarantee to the company, which then would enable the director to always assume that the company will be able to pay its debts because it can rely on the parent company guarantee. Of course, that is not always so such a good idea from the parent company's perspective, because that sort of destroys the liability, the limited liability, because it makes the shareholder directly liable for the debts of the subsidiary, which is not ideal, but just as an idea. As an anecdotal comment, the balance sheet insolvency test has been gutted in Germany in the last years. So for practical purposes, we also are economically limited to cash flow insolvency. That's interesting. Very good. Good. Personal liability. Yeah, the directors are personally liable for the breach of these 4 key duties that we talked about before. Then they're personally liable for insolvent trading, and also for other legislation. There is quite the exposure here in Australia, I must say, is quite high for the directors, but it's all manageable, and it mostly becomes an issue if the company goes insolvent, because the liquidator will be the one looking for angles how to hold the directors liable. As long as the company is not in liquidation, usually you shouldn't be too worried about it. Yeah. That's absolutely the same in Germany again. Yeah. Okay, and then here again, just some practical tips. So, of course, a director should always familiarize themselves with the company's business. They should know what the business does, and that's, of course, for a PTY Limited, where the directors are involved in the management of the business. That's clearly the case. But this is an important one also for these resident directors in Australia, because they do not work actively in the business, and therefore they have to be very careful not to get too distant from the business. Otherwise, they could be breaching their duties. And then, maybe Till, do you want to say a few words about the other points, because it's the same, I think, in Germany and Australia.
Absolutely, it's basically all those points are common sense, which is obvious, considering that the business judgment rule and the liability of directors are very open and generic, both in Germany and Australia.
Yeah. And then here, just on this last slide, we have a few points. The first one is typical for Australia. So in Australia, there is a thing called a deed of access, insurance and indemnity that all directors should have in place with the company and even the parent company, if there is one. And that enables the directors to have access to the records even after they cease to be a director, in case they get sued by the company, that they can have access to all this evidence. Then it's about that the company must take out insurance for the director, and also the company indemnifies the director for certain breaches, but there is a limitation on that under the Corporations Act, because the Australian Gesetzgeber was of the view that you shouldn't be able to indemnify the director for everything, because otherwise they would not do their job properly, right? So that's why you can't indemnify against everything. And I don't know, I haven't come across this sort of concept in Germany. That's not a common thing, right, in Germany, to have a deed of access, insurance and indemnity.
No, we don't have that. We do what we do have is a similar concept that companies are limited in how far they are permitted to take out D&O insurances for their directors, because it's the same thought that mandatory liability should not be undercut by having comprehensive D&O insurances. I think you have to leave a year of remuneration or something like that open to personal liability. However, directors can take out personal insurances against that remaining liability. So the thinking is the same. The execution is a bit different. In open companies, shareholders are limited in the amount of claims that they can waive against the directors, which is also a similar thinking behind it, I think.
Yes, that's right. Okay, and I think that is the end of the presentation.
Yeah.
Very good.
Thank you very much, everybody.